advice, but it's just for public sensitization. Please contact your lawyer for legal advice on every circumstance. Thank you. Alright, welcome to another edition of our program. And in today's segment, we are going to look at the tenant's rights. Now, why should we look into the tenant's rights? This is because it has become a controversial issue, and the court is now flooded today with the issue between the tenants and the landlord. Now, the relationship between a landlord and the tenant is strictly controlled by law, and any landlord who wishes to inject a tenant from his property must follow these laws completely. Now, the landlord and tenancy issues has become a rising issue today in Nigeria. The court is flooded with the suit in tenancy related matter, and the tenants suffer the more because they are not aware of those rights. And now, for you to even protect your rights as a tenant, you need to know those rights. Then, what are the rights do you have as a tenant? Now, in this segment, we are going to look at the right that is enjoyable by the tenant. One of those rights are: one, the right to receipt, right to an exclusive possession of the premises or property, right to quit notice before eviction, right to serving notice for the recovery of the possession, and right to habitable premises. And the final one that is more important is right to have the tenancy agreement reduced into writing. That is what we call the tenancy agreement. Now, let's take the rights one after the other. Now look at the right to receipt of the payment. Every tenant has the right to be given receipt immediately upon the payment of his rent. Once you pay your rent as a tenant, you are entitled to be issued with a receipt indicating the date of payment, the date of the commencement of the rent, the date that the rent will expire, and the amount paid. And another thing that should be indicated in the receipt is the location or the place where the property situates, the duration or the coverage of the sum paid. Now, failure to issue a receipt is an offense under rent and recovering of premises law of various states. Now, it is the right of every tenant that immediately or upon payment of the tenancy fee, the tenant is having that right that the receipt should be issued. Then why should you request for the receipt of payment? It is because whenever the issue of the tenancy matter is raised between you and the landlord, the first evidential document that should be looking into is the receipt of payment, because the commencement of the rent of the tenancy can be deduced from the date that is specified on the receipt. Then the second right that is enjoyed by the tenant is right to exclusive possession. Right to exclusive possession. Once you have paid for the premises as a tenant, it is deemed that you and the landlord has agreed on the terms of the tenants, and the landlord is duty bound to hand over the property to you as a tenant, thereby putting you in possession. Now, being in possession in this situation is called exclusive possession. Now, being in possession is called what? Exclusive possession. That is to say that the premises is exclusively for your own usage. Exclusive possession is the right of the tenant to use the property to the exclusion of every other person, including the landlord and his agent. Now, what this right of exclusive possession is talking about is that as soon as the rent is paid and the landlord hands over the key of the premises to you, no any other person has the right over that particular property. They have put you on the exclusive possession. They have put you alone to have rights and power over that particular property until the expiration of your rent. Now, even your landlord needs your permission before he could enter the apartment when you are having exclusive possession over the property. And if anyone, including the landlord, enter the premises or the apartment without your consent and approval as a tenant, such a person can be sued for trespass, which cost can be awarded against such trespasser. Remember, your landlord can also be a trespasser in his own property. But before you enjoy this exclusive possession, it is when when your rent is still subsisting. It is not when your rent has expired. Now we are looking at the third right of the tenant. The third right of the tenant is, as we stated earlier, his right to quit notice. Right to quit notice. Now, before a landlord can inject or evict you from his property for any reason, he must first and foremost serve you with the requisite notices. And the notice is determined by the nature of the tenancy. Now, before the commencement of any action against you, before a court can have jurisdiction over the matter of tenancy between you and your landlord, the first thing that the landlord ought to do is to give you the notices. And the nature of the notices to be given is determined by the nature of the tenancy. Now, what are the nature of these tenancies? One, we have the various ways of the tenancy, or as it is literally called, the types of tenancy. Now, the type of tenancies are: one, we have what we call weekly tenants, we have monthly tenants, we have quarterly tenants, and we have yearly tenants. And also, we have tenants at will and fixed tenant. So, the nature of the tenant that is operational between you and the landlord is what will now determine the nature of the notices to be issued. Now, if you are a weekly tenant, you are entitled to a week notice. Then, if you are a monthly tenant, you are entitled to 2-week notices. And if you are a quarterly tenant, you are entitled to 3 months notice. And if you are a yearly tenant, you are entitled to 6 months notice. But if you are a tenant at will, you are only entitled to 7 days notice. And if you are a fixed tenant, you are not entitled to any notice. Remember, if you are a fixed tenant, you are not entitled to any notices. Reason being this, for the issue of fixed tenant, because since at the commencement of the tenant, you are deemed to know the date that your tenancy is going to expire. So you have a fixed time with your landlord. So your landlord need not to give you notice again, since the period, the duration of the tenancy is fixed. And for us to have to be on the same page with respect of the notices, remember, your entitlement to these notices, as earlier stated, does not mean that you should be given the notice at the expiration of your rent. No. The notices to be given, before it could be valid, it has to be issued while your rent is still subsisting. Whatever notices that is given after the expiration of the rent, it is not valid. any notices that is given, for instance, if you are a weekly tenant and after the expiration your tenancy within a week and you are now giving a weekly notice, it is not valid. What the landlord ought to do as a weekly tenant is that as soon as you pay for that week, that particular day, he will give you the notice that at the expiration of your rent, you have to hand over the property to him, or you have to quit from the property. Likewise to the yearly tenants, for instance, because that is the one that is more rampant. And if you are a yearly tenant and you are entitled to this 6 months notice, the 6 months notice ought to be given when your rent is still running, when your rent is still subsisting. You are not entitled to 6 months notice at the expiration of your rent. Do we get that clear? You are not entitled to 6 months notice at the expiration of your rent. You are only entitled to 6 months notice when your rent is still subsisting. For instance, if your rent commence from January 2020 or 2021 or 2022, as it may be, your rent ought to expire in December of that particular year. Now, if the landlord is to give you the quit notice, to notice the notices, the required notice of 6 months, you are supposed to be giving the notice in June of that year that your rent is still, that you are still left with 6 months to the expiration of your rent. You are not entitled to 6 months after the expiration of your rent. Now, what you are entitled to after the expiration of rent is determined by the law regulating in that particular state. Now, that is the topic that we are going to discuss next, because in various states, every state has the law that is regulating the issue between the tenants and the landlord in that particular state. Now, but note that for a fixed tenancy, as I said earlier, the landlord need not to serve you any notice to quit, because the presumption, as I say, the presumption is that you are already aware as to when the rent will expire. Alright, now the next right that is enjoyable by the tenants is right to serving notice to recover possession. Right to serving notice, 7 days notice to recover possession. Remember, the first one that we looked at, that is right to notice to quit, is to give you the notice that at the expiration of this your rent, you are to quit or hand over property to the landlord. You are to quit from the landlord. But in this fourth right, which is the right to 7 days notice, is that the landlord has to serve you the notice that he has the intention to recover his premises. That after the notice to quit, remember, after the notice to quit, all tenants are entitled to be served with 7 days notice of owner's intention to recover the premises. This notice is followed after the notice to quit has expired. Remember, this notice of 7 days owner's intention to recover premises could only follow immediately at the expiration of the notice to quit, not when the notice to quit is still running. Now, failure of the landlord or its agents to issue or serve this notice will deny the court the jurisdiction to entertain the matter. So what that meant is that before the court could have right, before the court could have power, before the court will have the right to adjudicate on the issue between you and the landlord, it is when and until these notices is being served on you. Then the fifth right as a tenant that you need to enjoy as a tenant is right to habitable premises. Right to habitable premises. It is your right as a tenant to live in a habitable, hygienic and comfortable premises. If for any reason during the pendency of the tenancy that the premise become inhabitable, that the premises become unhygienic, or the premises become uncomfortable to you, you have a right to request that the landlord should put the premises in a habitable state. In the event that the landlord refuses, as a tenant, you are entitled to terminate the tenancy and request for refund and request on the refund. And the refund that you request for will be calculated based on the number of months or days you have spent in the property of the landlord. So it is your right to have a habitable, hygienic and comfortable premises as a tenant. And one thing again that you should note is that you should be able to inspect the property before you check into the property, so that you should not expect that the property should be advanced above and over what you meant in the first place, on the ground that you have the right for comfortable and hygienic premises. So what you should know is that you should have a choice as a tenant, so that as at the time of the commencement, you should be able to do due diligence by inspecting the property and ensure that it is within the context of your interest as a tenant. Now, the final and most important right enjoyable by every tenant is right to tenancy agreement. Right to a tenancy agreement. Now, it is the right of every tenant to request from his landlord a written tenancy agreement. This is very, very fundamental. It is very, very fundamental. So, in my own view, that every prospective tenant should request for a copy of the tenancy agreement before money exchange hands. Now, it is very important that you should know the content of the tenancy agreement, the do's and the don'ts in the property that you intend to acquire. This is because it is very important to know the rules governing the premises that you are about to take. The tenancy agreement is very important because it outlines the terms of the tenancy. It spells out the do's and the don'ts. It spells out the responsibility of the landlord or its tenants. Now, within the contents of the tenancy agreement, it will be clearly stipulates the responsibility, what the landlord ought to do while you are in the premises of the landlord, and what you as a tenant ought not to do when you are in occupation of the landlord property. What you should have at the back of your mind as a tenant is that if your landlord institutes an action against you in court and you engage the service of a lawyer to delay or frustrate the landlord, bear it in mind that the court will order you to pay for the number of years spent while the matter is still pending in court. If the matter lasts for like 10 years, for the payment, for the matter lasts for like 10 years, the tenant is expected to pay the 10 years during the pendency of the matter. Though, as at the time that the matter is going on in court, you are not expected to pay the money. But when the judgment is given against you, even if the matter lasts for 20 years, the law is that you must be paid for those number of years because the judgment has been given against you. But one thing you should know about the recovery of premises is that The only thing is that the steps taken by the landlord can be faulty, which will make the matter to be struck out. But one thing is that when the landlord goes back to do the needful by taking the necessary step and he commits the action against you, the judgment will be given against you, since you are a tenant. The only ground of which you can raise the issue that you will not pay the rent is when the ownership of the property is an issue. For instance, when you are in a property and you presume that that property is yours and another person is coming to collect the rent from you, and the person is suit an action against you for the recovery of the premises, you can raise the issue of ownership. That is only ground of which you will not pay the rent if the judgment is given in your favor. But if the judgment is given against you and in favor of the landlord, the law is that you will pay the rent demanded by the said landlord, which the judgment is given in his favor. So now you should have it in mind that what we have stipulated earlier is the right enjoyable by you as a tenant, that you have the following right as was earlier stated, that 1, you have the right to a receipt, 2, you have the right to exclusive possession of the property of the premises, 3, right to notice to quit before injection, 4, right to 7 days notice to recover possession, and 5, right to inhabitable premises, and finally right to have the tenancy reduced into writing. Thank you for watching, and in our subsequent edition we will try to educate you on the various rights that you need to enjoy as humanity. Thank you, and thank you for watching.